Jerry, thanks for joining us.
Happy to be here.
What is the biggest mistake you see advisors currently making when it comes to their fiduciary responsibility?
Not really drilling down and looking at the details of a plan. They've got to remember that they are held to the standard of a prudent financial expert, familiar with industry practices, and they should not take the superficial way out. They've got to get familiar with the details, benchmarks, performance, and fees for things such as record keeping as well as investment management.
Some plans are so small that the advisor might think, well, nobody's really going to know about that. Why is that a problem, and what do you suggest they do?
John, it's a problem for multiple reasons. Yes, the cases that we've brought have been against large plans, but first of all, the DOL now has its eye on fees in a way they never did when we started this almost 10 years ago. The DOL can bring a case without regard to the cost. Private lawyers are looking at this more and more in smaller plans, and private lawyers can get reimbursed for their attorney's fees if they bring a case and succeed. But the other factor that an advisor should be thinking about is this. Reputational risk is a serious risk if there is a plan that they're advising and has egregious facts that come out, whether it be in the media, come out in a court case, if they haven't been doing their job. That reputational risk could affect their whole business. It could be one case could affect everything for them. So it's not worth taking a chance that it isn't going to be noticed. The best thing is be upfront, advise as you would a bigger plan, and if that means that you have to advise that the plan should get rebates for previous fees that were excessive, say for record keeping, advise your sponsor, your client to do so. Because you shouldn't have to think you may get caught or something like that in approving a plan that was egregious.
Some plans are so small that they might not know that they're paying a little bit more. Therefore, the advisor might not want to rock the boat. Why is that a problem? What kind of exposure does that open them up to?
Well, first of all, revenue sharing is not a violation of the law. It's whether the revenue sharing produces an excessive fee. And when you have an asset-based charge for record keeping, which doesn't have anything to do with assets, the cost of that has nothing to do with asset size, that's where you run into problems if those are paid for with revenue sharing. What do you do if you have that situation? My advice, without any question, is recommend that you go back and obtain rebates for the plan, do the right thing going forward. You're going to be better off as an advisor if you do. Obviously, you can't control what the plan sponsor ultimately does. But if you're on record and make that record that you advise the sponsor to recapture the excessive fees and going forward to make sure that any excessive amounts are rebated to the plan, you've done your job, you've protected yourself, and you're going to be better off. Plus, you'll probably sleep better at night.